Good morning, this is the Kelso Report for Friday, August 17th, and I'm your host, Clark Kelso. We begin with a close 6-5 in Bank from the Ninth Circuit in Sessoms versus Reynolds, where the court held yesterday that state courts had unreasonably applied clear Supreme Court precedent on the question of whether someone had invoked his or her right to counsel. The majority held that the petitioner's request for a writ of habeas corpus should have been granted. The petitioner in this case voluntarily had turned himself in. He was seated in an interrogation room, and when two officers entered, the following exchange occurred. Petitioner: "There wouldn't be any possible way I could have a lawyer present while we do this." Detective: "Well, what I'll do is, Petitioner: "Yeah, that's what my dad asked me to ask you guys. Give me a lawyer." Instead of immediately ceasing the interrogation, the officers persevered and convinced the petitioner that the only way to tell his side of the story was to speak to them without an attorney. Eventually, the petitioner agreed to talk and made incriminating statements. There were two issues here. First, a legal question, whether, under the Supreme Court's decision in Davis versus United States, a 1994 decision, the petitioner's request for counsel had to be unambiguous. Second, whether in fact his request for a lawyer was unambiguous. Davis had held, in a post-Miranda warning context, where the defendant had already waived his Miranda rights, that any subsequent request for counsel must be unambiguous. The Ninth Circuit majority held that it was an unreasonable extension of Davis and other cases to apply that approach to a pre-Miranda warning request for counsel. The court also held that even if the Davis standard applied, the petitioner's request for a lawyer was in fact unambiguous. The five-judge dissent focused its attention upon the highly deferential standard of review that applies in habeas matters, and concluded that a reasonable judge could have determined that Davis applied, and that the petitioner's statements were not an unambiguous request for counsel. Now, this close-in Bank decision is nicely set up for Supreme Court review, both as to what it means to defer to state courts in a habeas case, and how police should interpret a pre-Miranda warning request for counsel. So I suspect we'll see this case on next year's Supreme Court docket. Ninth Circuit had another habeas case yesterday, this one just with a panel decision. The petitioner in Jones versus Ryan had been convicted of 6 murders by an Arizona state court and sentenced to death in 1998. He raised a prosecutorial misconduct claim and a Brady claim. The Ninth Circuit affirmed the district court's denial of this petition. The claim of prosecutorial misconduct, that's an extremely difficult claim to win, particularly so on habeas. To gain habeas relief, the petitioner must show that the alleged misconduct so infected the trial with unfairness as to make the resulting conviction a denial of due process. That's a high standard to meet. In Jones, the petitioner was not even close. The petitioner alleged that the prosecutor crossed the line from preparing the witness to unlawfully manipulating evidence to influence that witness's testimony and then suborned perjury. It was clear after the fact that the prosecutor had confused 2 pictures that were admitted into evidence and had misstated a detail about one of the pictures. But the detail was not even a material fact, and the court held that such a minor error was plainly excusable and did not rise to the level of a due process violation. As for the Brady violation, at most there was a brief delay in turning over some evidence, but the evidence was turned over a full 2 months before trial, so the court also rejected that as a basis for habeas relief. Now we turn to the Supreme Court of California. In Pinnacle Museum Tower Association versus Pinnacle Market Development, the California Supreme Court faced the question of whether an arbitration clause contained in a condominium's covenants, conditions, and restrictions bound the owners' association to arbitration, even though the CC&Rs predated the existence of the association. The underlying lawsuit was for construction defect. The association argued that consent is a necessary prerequisite to an enforceable arbitration clause. And since the association was not even in existence when the CCRs were drafted and filed, there was no evidence the association had consented. Well, that argument usually works. Usually you do need consent. But the Supreme Court of California disagreed here. The usual statutory and case law pertaining to common interest developments is to the effect that covenants and terms in the recorded CC&Rs reflect written promises and agreements that are subject to enforcement against owners in the association. Now, there's no reason why that usual law should not apply in the context of arbitration clauses, so the Supreme Court concluded that the arbitration clause did indeed bind the association. In fact, I would bet that if the court had come out the other way, creating a special rule that arbitration clauses in CC&Rs were not enforceable, even though the rest of the CCRs were enforceable, I'll bet the United States Supreme Court would have taken that case up and reversed, because the clear message from the U.S. Supreme Court over the last decade is you can't have special rules that disadvantage arbitration clauses. The Supreme Court of California got this one right. Next, a fascinating juvenile sentencing case from the Supreme Court, California. 2 years ago, in Graham versus Florida, the U.S. Supreme Court held that the Eighth Amendment prohibits states from sentencing a juvenile convicted of non-homicide offenses to life imprisonment without the possibility of parole. In People versus Caballero, the California Supreme Court decided yesterday that a 110-year to life sentence imposed on a juvenile convicted of non-homicide offenses also contravenes Graham's mandate against cruel and unusual punishment. More generally, the California Supreme Court held that sentencing a juvenile offender for a non-homicide offense to a term of years with a parole eligibility date that falls outside the juvenile offender's natural life expectancy violates the Eighth Amendment. Now, this does not necessarily mean an early release, of course. As the court noted, although proper authorities may later determine that a youth should remain incarcerated for his or her natural life, the state may not deprive juveniles at sentencing of a meaningful opportunity to demonstrate their rehabilitation and fitness to re-enter society in the future. Under Graham's non-homicide ruling, the sentencing court must consider all mitigating circumstances, including but not limited to the juvenile's chronological age at the time of the crime, whether the juvenile offender was a direct perpetrator or an aider or abettor, his or her physical or mental development, so that it can impose a time or a sentence when the juvenile offender will be able to seek parole from the parole board. California court's decision is a little bit of an extension of Graham's precise holding, but it is nevertheless an extension fully supported by the Graham court's reasoning. Next we go to the California Court of Appeal, a health law case involving statute of limitations. Now, the Administrative Procedure Act sets strict time limit deadlines for judicial challenges to administrative decisions. For a licensee of the board to challenge an adverse licensing decision by petition for writ of administrative mandate, there are two 30-day deadlines that apply. First, unless the board grants a stay to allow the licensee to apply for reconsideration, Government Code Section 11521 provides 30 days after delivery or mailing of the decision to the licensee as the last day on which the decision may be reconsidered. Second, unless the licensee timely requests preparation of the administrative record, the licensee must file a petition within 30 days of the last day for reconsideration if she wishes to challenge the board's decision. Well, in Hansen v. Board of Registered Nursing, the 4th District concluded the nurse had not satisfied either of these alternatives, and the court rejected her legal argument that the running of the limitations period should automatically be tolled until she actually learned of the revocation. The board mailed its decision to her address of record by certified mail, which the applicable statute specifically authorized, and that started the clock she didn't get her petition in on time. And that's it for today's Kelso Report. Have a great day in the law.